United District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jason.
You may be seated. Court does call the case of the people of the state of Michigan versus Sherrone Moore. Counsel, please state your appearances for the record.
Good afternoon, Your Honor. Katie Wisworski for the people.
Good afternoon, Your Honor. Ellen Michaels on behalf of Sherrone Moore, who is present in court. Please state your name for the record.
Sherrone Moore.
Thank you. All right, you may be seated. And I guess the first order of business, Counsel, this is your motion for a Frank's hearing, and I'll let you go ahead with that. There was, however, a motion that you had filed in the latter part of last week requesting permission for the court to accept a reply brief. Did the people have a response to that? I will just say this, the information, the legal information contained in there, I already had done the research, so I knew it.
Agreed and the same, and the court can take it for whatever the court thinks its import is. I plan to respond to it, if only briefly, formally, if that's acceptable to me.
That's acceptable to.
Thank you.
All right, very good. All right, thank you.
Good afternoon. May it please this honorable court. Thank you for accepting my motion in reply to the prosecutor's response on this issue. The importance of the reply that I filed is that it states clearly and unequivocally that the relationship between the parties in a stalking allegation matters. It's not stalking if the communication has a legitimate purpose. As stated in my reply, and as what Your Honor knows, is that under recently published appellate court case in the state of Michigan, it is clear that the relationship between the parties matters. In that case, there was a stalking charge and there was a trial. At trial, the evidence presented that the alleged victim was a probation agent and that the alleged defendant was a probationer. The probationer contacted his probation agent many, many, many times, to the point where the probationer said, "Please stop contacting me." The probation agent felt harassed. She had her stalking charges filed. At a bench trial, there was a finding of guilty. On appeal, the appellate court stated that the employment relationship is relevant, that the relationship between the probationer and the probation agent is relevant. That it's relevant because what it shows is that contact between the two parties had a legitimate purpose. The contact was for the probationer to notify his probation agent of certain things. What the court said was that when looking at the reasonable person standard of whether somebody feels harassed, you have to look at whether a reasonable person in that position feels harassed, which gets us to what happened in this case. In this case, Detective Welker presented to the magistrate facts to seek an arrest warrant for Sherrone Moore on stalking charges and on home invasion with intent to stalk. In the facts that she presented to the magistrate, she left out the information that Sherrone Moore was the boss of the complainant. The complainant was the executive assistant to Sherrone Moore, who at the time was the head football coach at the University of Michigan. Why does that matter? It matters because the communications that were presented to the magistrate were 12 alleged phone calls that were unanswered. The 12 alleged phone calls were on a work day. The complainant in this case had not taken a leave of absence. She had not left her job. It was working hours, and she was the executive assistant of Sherrone Moore. Sherrone Moore was never told not to contact her for legitimate purposes. In fact, he was never told not to contact her at all, but that's not what we're here arguing right now. I'm talking about the legitimate purpose. If there are contacts for legitimate purpose, it is not harassment. As I stated a moment ago, the phone calls went unanswered. So there's no evidence as to what the intent of those phone calls were. I can tell you that there was evidence in the police reports that were tendered to me by the prosecutor's office that a text message was presented to Detective Welker by the complainant's attorney as a way to show, look, he's contacting her and she is feeling harassed. It was a screenshot of several text messages. In those text messages were several
You're
messages.
talking about one before December 10th?
There was a screenshot of messages where there was messages from December 9th and December 10th, the days that the alleged stalking occurred.
That were presented, you're saying that there's in the report, because by design, I don't have the police.
Correct.
Right. So are you saying in the police reports, there are text messages from, what would it be, the 8th and 9th or the 9th and 10th? But prior to the 10th?
Correct. Yes. The police report is where I obtained that screenshot that I presented in my motion. That's how I know Detective Welker had that information, because it was tendered to me in the police report from the prosecutor's office.
How many text messages were in that report?
In that screenshot?
Well, you're saying that in the police report, there were a number of text messages.
There was a screenshot of a conversation. And in that screenshot of the conversation that is on page 5 of my original motion,
Yeah.
there are, it starts, can you have Dave write a statement? Okay. What is the latest you can get me out? I called him. And then that would have been on Monday, December 8th. Tuesday, December 9th is one text message that says, please answer. And then on the day of the incident, it says, can you call me when you get a chance?
So what was laid out in your brief, those were text messages from various days.
Correct.
Got it. Okay, go ahead.
Yes. That screenshot was presented to the complainant by Detective Welker, and Detective Welker asked her about those messages. And in the conversation, which is documented in the police report, Detective Welker was told by the complainant that the first message and the second message and the third message were work-related. The complainant confirmed that they were work-related. The one where it says, please answer and call when you get a chance. It's my belief that those text messages were also seen as work-related. Those were not part of.
Well, it's your belief, but did she say that, or?
She said to the detective said, was this work-related? And she said, yes, that's work-related. They showed her the whole screenshot, and she said, are these text messages work-related? And the answer was, yes, those are work-related. And then she was asked, are there any more text messages that you haven't given me? And the answer was no. And that's all in the police report.
Okay.
So the reason, again, to connect the dots is that there's acknowledged communication that was work-related during those days, which goes towards the phone calls. She doesn't know if they're work-related or not. We don't know if they're work-related or not. It's our position they were. It was a work day. There's no evidence to show otherwise. Because the complainant was able to distinguish between communications that were work-related. She identified the text as work-related.
Okay, let me ask this. Again, I don't have the report. Was information presented to the detective of that these phone calls were actually made?
No, there were no phone records at that time. It was verbally said. There were no phone records. It was presented
I
to.
understand that there may not be phone records, but was there a phone log at all?
Yes, I have to look. I'm not disputing the fact that there were 12 calls made, if that's what you're asking. There were
Right,
calls
but,
made.
here's, I guess what my point is that it doesn't indicate in the swear to that it indicates that the complainant is saying these things, but it doesn't say we look and here they are.
Correct.
All right.
Yes.
So I'm just trying to make sure what was, I guess, at that time known.
It was known that these calls, that she received phone calls from Sherrone Moore that were unanswered. That's what was known.
Okay, so again, I'm just trying to clarify in my own mind. Between the 8th and the 10th, there were phone calls.
Correct.
We don't necessarily have call logs, but there are phone calls. Not that you're not disputing that. But none of these phone calls were answered.
Correct.
Okay, all right, go ahead.
At the time of the swear to, Detective Welker knew that there was an employee-employment relationship. And that wasn't presented to the magistrate.
Are you saying that that was intentionally done or just done?
I believe it was intentional, but I don't believe that I have to prove that. I think that the fact that it is a relevant and material fact to a stalking charge makes it relevant and makes it a material omission.
Well, I have two questions for that. Do you have any case law where a hearing of this type, which we'll call a Frank's hearing, but may or may not be, but was an evidentiary hearing was then conducted based upon omissions as opposed to false or intentionally reckless statements?
I, in fact, have a case where that was the case in Oakland County, People versus Galloway. We had a 3-day evidentiary hearing based on the omission of relevant information that a tip came from a privileged source. And Judge McMillan at the Oakland County Circuit Court granted my motion for a Frank's hearing, ultimately suppressed evidence that was appealed to the Michigan Appellate Court, and that was upheld. There's quite a bit of case law where omissions are considered Frank's violations.
Okay, go ahead. Well, just one other question before you go on. In paragraph 10 of your original motion, you stated that there were, I guess, fraudulent statements that were made. And I'm trying to figure out what those may have been.
Okay.
Did you want a copy? I have.
I had a copy. Oh, I have it right on top. I'm sorry, in paragraph 10.
Paragraph 10, you state that Detective
Yes.
Walker knowingly and intentionally and or with reckless disregard presented false testimony.
Yes.
And I guess when I read these swear to, I was trying to figure out, and looking at your brief, what are you claiming that's false that she presented?
I thank you. That's a great question.
I know I asked it.
Yeah.
Go ahead.
Yeah. The information that Detective Welker presented at the swear to, a large portion of it came from information she received from Heidi Sharp, the civil attorney who was representing the complainant in going to general counsel at University of Michigan to disclose this relationship that is the basis of this part of how we got here. This Heidi Sharp is when Mr. Moore came to the complainant's apartment, the first person that the complainant called was Heidi Sharp. Heidi Sharp then calls 911 and says a series of statements that are in my motion that she did not have personal information of and had no basis for and are untrue.
Okay, that may all be well and good. I understand that portion of your argument. But in paragraph 10, you're saying that the detective intentionally gave false testimony, submitted false testimony.
Right, I'm
Now,
getting there, so,
If I'm the detective and I'm relaying what somebody told me to the court, I don't know that that's false.
I understand. So what happened was, after this attorney who was not present gave this information, the actual complainant was interviewed on 3 separate occasions at her residence, which was all on the body worn camera that I reviewed. The body worn camera statements made by the complainant were a part of the police report. Then there was a follow-up phone call with Detective Welker to the complainant. The information the complainant gave to Detective Welker conflicted with the information that Heidi Sharp gave the detective. So
But that doesn't mean that Detective Welker presented false testimony. It just means that, which seems to me to be at the core of your argument, that there was information that was omitted.
well, if Heidi Sharp, who was not a witness, said something that the actual witness contradicts, then it is false. Or unless you're saying that the person who wasn't present is more reliable than the person who was present. It was contradictory.
I get kind of what you're saying, but
Okay, I'll take it a step further.
okay.
Heidi Sharp stated that Mr. Moore had a long history of domestic violence against Shiver. Okay. Shiver herself never made those statements. She never gave that information. There is no record of any of that. There is no documentation of any of that. There is no criminal history. There's nothing to support that statement made by Heidi Sharp. Through 3 interviews, the complainant never says any of that and also doesn't support it. She was asked by Detective Welker about assaultive behavior, and she said, no, there isn't any. Heidi Sharp's comments were completely contradicted, and Detective Welker, by submitting to the magistrate Sharp statements instead of the complainant's statements, was reckless and intentional and false. And the purpose of a Franks hearing is...
I don't know. See, I'm still having an issue with the false part. I get your argument regarding what may have been reckless or an omission, and either reckless inclusion or reckless omission. I get that part. I don't know that, could it be what you're really trying to point out to the court is that by placing that information in, the context of the relationship was placed in a false light, as opposed to what she said being false. Because what Detective Welker says is, yes, this is what Ms. Sharp said, right? But that's only half the story.
That is a way to look at it, but I do believe it goes a step further, that a detective is an officer of the court. It is their job to investigate. It is their job to present truthful information to a magistrate, to show the picture in order to get for the magistrate to make a determination. The magistrate needs information to make a determination of probable cause of whether to issue an arrest warrant. That's a big deal. That's like due process at its core. And in this case, where the detective talked to Heidi Sharp and the complainant numerous times, had a picture of the whole situation, had an ability to ask the complainant if it was true or not, had an ability to ferret out what was really going on here, and then present it to the magistrate in a fair and honest way to paint an entire picture. That's her duty under the law. And in this case, the picture that she painted was inaccurate, not supported by the facts of the person who was present, not to mention the omission of the employment relationship.
Ms. Nichols, and I mean, we can move on from here. I mean, we might be saying the same thing in a different way, but it really isn't that it's false. It's that she may have portrayed an inaccurate context to everything that's going on by omitting certain things. I don't know that that makes what she said about what Heidi Sharp said false. It's just you haven't given me everything
Right.
to give context to what she's saying, whether to ignore it or not.
Right. I guess maybe the better language would be reckless disregard, which is also part of the analysis. I think reckless disregard is more accurate.
Okay. I asked the question because saying that somebody submitted deliberately false information may be a little bit different from somebody that is sort of reckless in what they present. But go ahead.
Thank you. So to get back to what we're asking for, we're simply asking for the opportunity to create a record, to put witnesses on, to create an evidentiary record, to show what they knew and when they knew it and how it was versus what was presented. We believe that we presented enough of an offer of proof as to what was given to me in the police reports. That's the information I want to go on the record. I am not presenting anything that the prosecution doesn't already know, but I believe that in the interest of justice, a record should be made to establish the information that was given to the magistrate with reckless disregard for the truth and the omission of the employee-employer relationship, as well as the omission of the acknowledgement by the complainant that she recognized that communications between her and Sherrone Moore were for business and knew the difference, and acknowledged that during these days in question, there was communications that were legitimate. And if the communications were legitimate, it is not harassment. And if it's not harassment, it's not stalking. May I have one moment? Sorry.
I just want one other question on the last point that you bring up. The relationship itself, one can have different relationships. I mean, so a phone call may be for business purposes or might not, right?
Correct.
Or there could be a communication that has a mixed purpose. Correct? I mean,
Correct.
because there are different relationships going on.
Correct.
And in viewing it as to whether or not a stalking and the harassment occurs, the court would have to take into account that those two things can exist at once, right?
Correct.
Okay.
So in doing that, when there's things that we don't know, we often look at circumstantial evidence. So what's the circumstantial evidence here? The circumstantial evidence here is that it was a work day, it was work hours, the employee-employer relationship was intact. There were text messages that were work-related in those time frames that these calls allegedly occurred. And it was, in terms of the dates involved, that was the week that Michigan had found out who their bowl opponent was. And there was all hands on deck.
You know what bowl it was?
Yeah, it was the Citrus Bowl in Texas.
You had to turn and look. No, I don't need to know. I was just asking.
I knew who the opponent was. I couldn't remember Citrus. It was a Citrus
It
Bowl
was a
against
Citrus
Texas.
Bowl against Texas.
That Sunday night, they received their opponent.
Right.
It was all hands on deck. So I believe those facts are relevant. If this were August and it was a break from the program, yeah, there could be a question. But the circumstantial facts of the timing of these calls, and remember, or not remember, but I will state that at the time these calls were made, Mr. Moore had not been told not to call her and had no idea that she had even gone and talked to general counsel. He didn't know any of that. He was operating in his job.
But wasn't there a call from, or her indication not to call? Or, well, the statement's a little bit different than that.
The statement is she said that she didn't want to talk about it anymore, or she didn't want to talk to him anymore, something like that. Not don't call me, not I'm never going to talk to you again. It was more vague and did not address the employee-employer relationship either. It didn't say, I don't want to talk to you and I'm giving notice. I don't want to talk to you and I'm asking for a transfer. I'm taking 3 days off of work. Don't contact me. That would all be context to show that they were personal calls. None of that occurred.
I think it's important to point out what, according to the swear to, at 6 a.m. on December 8th, she told him that she had nothing more to say to him.
Correct. Which is different from I'm taking a leave of absence. Don't call me. I'm taking days off. Nothing about that indicates he should not call her for employment purposes. The point being is that in order for the court to properly evaluate probable cause, the employment relationship is relevant. We can't even evaluate, or we're having a whole conversation about whether or not the call was for employment purposes. The magistrate wasn't even told of the employee-employer relationship. So this conversation in itself is showing that that was an important piece of information for the magistrate to have known, therefore it's a relevant omission. And just one more piece, just going, actually, thank you.
All right, very good.
Thank you.
Mr. Sheminsky.
Thank you, Judge. Does the court have a place at which you would prefer for me to begin, or any specific questions?
You can start where you'd like. I guess maybe we should start where the defendant started, and that is the relevance of the work relationship.
I honestly would end there, but if you would like for me to start.
Well, it's your argument, so I'll let you go wherever you'd like.
Thank you, Judge. Is it all right if I pace, I think, better when I'm on?
That's fine. I do the same.
Where I start is actually not in my pleadings, and I beg the court's indulgence for a moment, because there was a legal factual issue pertaining to this ask that I struggled with at first. At first it was, hey, does Franks apply to arrest warrants? I only know Franks to apply to search warrants. Can I wrap my brain around this? I believe Franks applies to warrants. I've gotten myself there. Arrest, search warrants. I think there's substantial body of case law for you to infer that it can apply to arrest warrants. I think what I struggled with most after that is that defendant's ask has always been that you quash this arrest warrant and that you must therefore at that point dismiss this case. And I see no legal authority for that ask. I have found no legal authority for that ask. I have instead found 2 Michigan cases that I think address the issue. Maybe not head on, somewhat head on. People v. Burrell and People v. Smith. Happy to give the court citations,
Please.
if that is of assistance. People v. Burrell is 391 Mich 124. It appears to be a 1974 case. People v. Smith is 106 Mishap 203. It's a 1981 case. They
Said Mishap 203.
Say it again. 203.
203.
Yes, Your Honor.
Thank you.
Those cases draw a distinction between this court's jurisdiction and a case existing and your ability to proceed with that case versus the quashing of an arrest warrant. Typically, we think of remedies when a court quashes a warrant is that there is suppression of evidence that flows therefrom, right? That's what Frank's is about, search warrant. They were arguing you should suppress the evidence that came from getting this search warrant. What I feel they should be asking, what I can find legal authority for, is if there had been any evidence that flowed from the issuance of this arrest warrant, that they could and should be asking for you to suppress that. But this is sort of a backwards kind of a presentation. That might exist in a situation where there was not a warrantless arrest, where they had perhaps conducted an investigation, written reports, submitted them to my office, asked for charges, gotten an arrest warrant, went and arrested, and then perhaps did a search incident to arrest, then perhaps got some statements from defendant. That would be evidence that would flow from the issuance of an arrest warrant. Should you, which I don't think you should you grant a Frank's hearing here, and should you further, which I don't think you should, quash this arrest warrant, you're still left with a validly filed complaint. And while, again, I can't find exact case law to spit this exact holding out for us, what I will cite to the court is things like the statutes and the court rules that pertain themselves to, let's say, preliminary examination. And they don't talk about holding a preliminary examination and then at the conclusion of which, if the court finds probable cause to bind the defendant over, that you bind him over on the charges in the arrest warrant, you bind him over on the charges in the complaint. Because the complaint is how we start a lawsuit. Civil, criminal, that's what that is. That's the pleading. That exists. So my position is, what I didn't plead, is that even if you granted everything they asked for, you can't get to, they have not shown you authority for dismissing this case.
Well, maybe not dismissing, maybe, but what if there were not, the court were to go through an evidentiary hearing, get to the end and say, well, if the information that defendant wishes and should have been included before the magistrate, that if that information is there, there would not be probable cause for stalking, then the stalking charge, the complaint would still exist, but the stalking charge would fail. And by necessity, so would the felony, because the predicate offense is the stalking.
And then you would have held the hearing on the complaint. You would have evidence and information on that complaint and get to exercise what we count on you for, which is your decision-making to find or not find probable cause on the charges as they are laid out in the complaint.
Correct.
Judge, as to whether or not defendant is entitled to a Frank's hearing, of course, my pleading and my position is that he is not. Frank's talks about there needing to be a substantial preliminary showing before you make a decision to grant a Frank's hearing. Honestly, in Michigan, I think we go better than that. I'll do defendant a solid and say that I don't think that he actually has to show you substantial preliminary showing for you to make that decision. I think People v. Franklin, the 2017 Michigan Supreme Court case, stands for the proposition that this is your courtroom, your motion, your discretion. You get to do that if you see fit. My position is that to do that here would be an abuse of that discretion. I will note for the record that People v. Franklin, that judge clearly had his or her own opinion about the credibility of the CI that was in question, having been referenced in that search warrant. And so in that judge's discretion, based on that concern for credibility, that doesn't seem to be laid out very clearly in the record or in the written case law, that judge made that decision and it was upheld on appeal. So Judge, this is your discretion, but again, I submit that it would be an abuse of your discretion.
Would it really be an abuse of discretion if I were concerned about the context of the relationship that was placed before the magistrate? Because I'm not entirely clear why Ms. Sharp's statements are even part of the swear to. But her statements being part of the swear to creates a certain context of the relationship between Mr. Moore and the complainant in this case, right? So I'm not sure why that's there. The court, from the time I received Ms. Michael's motion, and then your response has had and looked at the swear to, has itself, before necessarily really closely looking at anything, had a concern about what was put before the magistrate. And mainly because having done swear tos regarding stalking cases, having presided over a number of stalking cases, one of the, I think, primary things that always comes out is the relationship of the parties and the extent of that relationship, so that the court can take into account why communication may be occurring. I mean, some of the, and you know this, say some of the egregious ones, there's no connection whatsoever between the parties, but all of a sudden it's happening. And then that creates one scenario. Then you've got other scenarios where you have an estranged husband and wife with children who are contacting. And then a court has to go through an analysis about what the context were. So would the court really, would I be in error to have concerns in reading the swear to that none of that was placed on the record regarding the employment relationship, let alone, might I say, and I'm not even at this point clear as to what the duties are of an executive assistant to a head coach.
I'm equally devoid of that knowledge and information.
But wouldn't that information, right, but wouldn't that information be important for the court to know?
So Judge, I wonder if I could spit back to you what you have said to make sure that
Sure,
I understand. Because
absolutely.
I appreciate the court's candor. And you told me to start there and I went ahead and started where I wanted to.
Yes.
So here we are, right. There is no question that most relationships have a context. And the court is correct. There is some stalking that exists in the world that is stranger to stranger, and it is what it is. I have encountered precious few of those. Most relationships have context. I think the court was very much in tune with the reality of this situation when the court earlier was questioning defense counsel and had some commentary along the lines of, but can't both things be true? Meaning, can't there be stalking and an employer-employee relationship? And the answer to that is, but of course there can. Simply because there might be some amount of communication between two people that is to be expected or a part of a job. But if it is used and abused to threaten and harass and perpetuate more and additional contact, conversation, varieties of contact, it should not negate stalking. What I will say is that I take issue with defendant's characterization of, I think you call it Eichler, E-I-C-H-L-E-R, the September 2025 case that they have cited to you about stalking. I think really what it stands for, my read of it, it's a commentary, it's a ruling and a holding on the status of the victim in that case. In that they said, because we all know stalking is a subjective and an objective standard to it, right? It has to have made a specific victim feel terrorized, threatened, harassed, molested, that list of statutory factors. The actual victim and a reasonable person also must have felt that way. And so what this case comments on and holds is that it's a reasonable person similarly situated to the specific victim in this case. In other words, would a reasonable probation officer have experienced this kind of communication to be threatening, harassing, molesting, so on and so forth? And the court went on to comment even further about sort of what it means to be a probation officer, and that you deal with individuals on the regular who have difficulty following direction. Court went on to underscore that this communication from this particular defendant did not involve any kind of threats, did not involve going to the victim's home or place of employment. It was simply texts, and they were all able to be characterized as about probation issues. So it is, while it does exist as a case in the context of an employment, if you want to call it that, relationship, it's very specific, in my opinion, to the specific roles that those two individuals played with one another.
Yeah, but that burden rests with the people to show that. Isn't that true? I mean, during the course of a swear to, that would have to be shown to the court. I don't make a presumption that it's one way or another, do I?
It would be our burden to show what at the
Well,
swear to,
at
Judge?
the swear to, it would be the people's burden, I guess. Seeking the complaint to show that somehow those, got to give me something that says it's something other than what might be work related, right?
I guess what I would then point the court to is that this complaint warrant alleges an incident on a date. I'm not saying that when we come to prelim here, should we get to that stage and this court orders a preliminary examination, I'm not saying that I wouldn't say to you, Judge, I'm looking to expand that date range. But right now, it is alleged December 10th, 2025. And as we all now know, since we're going to what we know, defendant was fired. And what we know, according to the complainant, as is testified to in the swear to, he called her 2 times after that. She didn't answer, showed up at her apartment, barged his way in, grabbed the implements that he did. She felt utterly terrorized in that moment, threatened to kill himself, pointed the implements at her, backed her further into her apartment, eventually left when she got her lawyer on speakerphone. And even after he left, then called her, as is witnessed on body cam, called her yet again, and sent her 2 more texts. I hate you, and my blood is on your hands. So on December 10th, and as was sworn to by Detective Welker, there is more than sufficient probable cause for the issuance of a warrant that includes stalking. That's my position. I have case law because I have had individuals question me as to whether or not behavior that occurs all on one day can satisfy the elements of stalking, that course of conduct, non-continuous separate acts. And while it is an unpublished case, Judge, I find a lot of takeaway from this case. It's People v. Smothers. So it's 2025 Westlaw WL 3483111. So it's a Mishap case. It was decided December 3rd of 2025. And it talks about 3 phone calls 3 phone calls that took place in barely over 1 hour can constitute sufficient evidence for aggravated stalking.
Were those phone calls answered?
Those phone calls were answered, but none of them, interestingly enough, were answered by the victim. They were phone calls that were made to 911 and either a city manager or a city attorney and the prosecutor's office. And they made threats against a specific deputy and specifically threats to kill. That deputy did not answer those phone calls. They were not made directly to that deputy, but they were communicated to that deputy. And that all was found to be sufficient evidence to sustain a conviction for aggravated stalking. So, Judge, I think on the record of the swear to, as it stands right now, when there was no longer any employment relationship because he'd been fired, there were multiple non-continuous, separate contacts that constitute stalking. I mean, I have another case that has barely even 2 contacts that was sufficient for an aggravated stalking conviction, but I give it to the court if the court.
But I guess, were the point of those that the information by the caller was communicated to the alleged complainant?
That certainly had to have happened for that to complete that loop. Yes.
Okay. But that's not what happened in this case.
No, you're absolutely right. There were the 2 on, if we're limiting our focus to December 10th, there were 2 unanswered phone calls by the defendant to the victim before he then came over and barged into her apartment and did the acts that he did, and then left her apartment and then called her again and then texted her 2 times. Which I would like to address the court's seeming discomfort with a failure to place on the record at swear to that there was an employment relationship, or perhaps what has been portrayed to the court as a disconnect between what Ms. Sharp, the attorney, communicated to the detective and what the victim communicated to the detective. Ms. Sharp, it appears defendant takes issue with 3 sort of statements or comments that Ms. Sharp made specifically. One is that defendant had been stalking the victim for months. The other is that he has a long history of domestic violence against this victim. And the third is that he is a very dangerous man. What I will first say, because counsel calls all of those false lies, and cites to the fact that there is no criminal history, there are no other police reports, things along those lines. Also cites to a follow-up conversation with Ms. Sharp, wherein she says, none of the acts that I'm talking about would likely rise to the level of physical abuse in your criminal world. But Judge, I'm sure you would agree with me that there are many different definitions of domestic violence, and also simply because something has not been reported to the police or there is no criminal conviction for it doesn't mean it doesn't exist, it hasn't happened. Specifically as it pertains to a definition of domestic violence, I always think of MCL 768.27b, so that other act statute, like when we go to trial on a crime that involves an act of domestic violence and we are allowed to introduce other acts of domestic violence.
Is Ms. Shiver claiming that?
Ms. Shiver did not, on the day that she was spoken to, December 10th, get into the history of her relationship with the defendant. One person did, and one person did not. Since then, there has been a lengthy additional interview and additional information, but we're not here about that. At that time, that was not something, for whatever reason or number of reasons, she was ready, willing, and able to talk about. She talked about December 10th and the fact that they had had an intimate relationship for a period of time leading up to that. So, Judge, to characterize Ms. Sharp's statements as lies simply because there isn't any adjudicated history of it, I just that misses the mark. There is no mandate that there be an adjudicated history of it for it to be an accurate statement, or at least an accurate statement in her mind. She goes on to talk about, a specific example she gives of what she means by that is that he has a history of threatening self-harm as a way to exert control over the victim, and that he has a propensity to use knives when he does that. So, Judge, we all know domestic violence includes a lot of things, and that emotional harm. I mean, again, I point the court to 768.27b in terms of definition of domestic violence, and certainly it could be causing harm or attempting to cause harm, but it can be placing a family or a household member in fear of physical or mental harm. It can be engaging in activity towards a family or household member that would cause a reasonable individual to feel, and then it lists off all of the stalking variables: terrorized, threatened, harassed, intimidated. That those are all under the umbrella, just in that one subsection of law, of what it means, what domestic violence can mean. So there isn't any showing that what Ms. Sharp said was false or a lie or inaccurate.
Well, but I think something might be, and this might just come from the court's knowledge of how long the college football season is. She stated to the officer, or to dispatch, I think, or somewhere, that he had been harassing her for months.
Yes.
Now, if I just take months as meaning 2, could mean more, and I take it from December 10th, that means that he was harassing her as the executive assistant through the majority of the Big Ten season. I'm not sure, and that's part of the court cut. I don't know how that works, how that would even happen.
Because I think that presupposes that the harassment she was talking about is just phone calls or texts that were maybe work related or that were work related.
So it was there then placed to be a context. It wasn't just something that the court should ignore.
The employment.
No, that Ms. Sharp's comments. I mean, somehow that creates, or it should have created, I guess, a context to the relationship that's going to form the basis of this stalking, in essence, right?
What Ms. Sharp is saying about it going on for months, that somehow will play into what happens here in this
On
case.
December 10th? No, on December 10th. I mean,
Yes.
well, then why wasn't it all given
Which
to the magistrate?
is the meaning that they had an employer-employee relationship.
Yeah, but it's even, and again, I don't know, but I'm just going to assume that it's different than just an employment-employer relationship. I mean, from the standpoint that it's almost like a CEO and the executive assistant to a CEO. I mean, the closeness of that relationship, I just don't know how the court wasn't informed.
If I had to guess, and that's part of what's challenging here, because we have one record, which is a transcript, and we're all sort of arguing from things we think we know from police reports and investigations. But if I had to guess, I would guess that it's because the detective assumed that as a fact, as a known fact. If I had to guess, I mean, that's about as honest as I can.
No, I understand what you're saying.
Yeah, I mean, it's one of those that seems like a judicial notice sort of a thing. by that time on that day. That's my best guess.
Well, it may have been a judicial no, I don't know if it would be. All due respect to head coaches around the world, I didn't know they had executive assistants. But whatever. I mean, I didn't know, but certainly the court, through the record, is not informed of that,
That would be
nor informed what that means. I mean, even as I sit here right now, and I don't know that anybody necessarily can explain to me what it is, I don't know what that relationship is. Like I said, I'm taking it from the standpoint that it's like a CEO and the executive assistant to a CEO, and that is typically a very close relationship. There's a lot of communication that happens. And as I was thinking about this case, the only thing that I could sort of in my head equated to is myself and my judicial coordinator, and that the communication that flows there is different than I have with any other employee in this court. It just is, by nature of the position. If I'm correct in that, and I may or may not be, I think it's something that the court would have had to have been informed of. Because at some point, even for a probable cause standard, the court's being asked, as I said before, to say that, and maybe the court would have had more questions as to what the nature of this harassment was for these months to create a context of this. Because like I said, I can look at it one way and say, okay, 6-7 games into the Big Ten season, and I can do that by just looking on my phone if I go 2 months back. And I can say, well, if I'm right about the relationship, the employment relationship, I don't know how that happens. And then I might, if I know that, ask questions about that, right? To put a proper context on these communications. So, I'm sorry, you may go ahead.
no need to be sorry. My position is that the detective testified to information that was given to her. Was there an omission of employer-employee, that fact? That would appear to be accurate. Again, my best guess is that she assumed that was a known fact. She testified to information that was given to her. The charge pertains itself currently, as we stand, to behavior on December 10th.
Can I just say though?
Sure.
I get what you're saying, but I'm looking at page 6
Of the swear to.
of the swear to.
Yep.
And starting at line 3, basically, she stated that after telling him this, that being that there was no more to say to him, that he continued to call her approximately a dozen times and sent her text messages over the next 2 days leading up to the date of the incident. Now, I just stopped there. If I have, it's, and I think everybody's right in terms of there needs to be a picture painted for the magistrate. If Miss Sharp is indicating that there's all of this other stuff that's going on, and so if I'm the magistrate, that's what I'm hearing. Then I'm hearing that this individual says that she has no more to say to him. And then there are these dozens of calls and text messages that occur over the next 2 days prior to this incident. Frankly, you'd be leading me to believe the negative because you're not giving me anything else.
Not sure I follow, Judge. Leading you to
Meaning
negative.
that these communications couldn't have been for any other purpose.
Mm.
I mean, because it's equally as plausible that I guess that they could be for the purposes of harassment as for the purposes of work relationship. But by placing it on the record this way before the magistrate, you've given the magistrate no alternative but to believe that it is a continuation of the behavior that Ms. Sharp describes, which I don't know if substantiated or not. That's my problem.
I think the best I can offer the court along those lines, with the exception of not having sworn to the fact that they were employed together at the U of M, that Detective Welker passed along the information that was given to her, swore to and testified to the information that was given to her.
Well, I got a problem with that too.
Yeah.
Because part of the problem is my understanding, and maybe I'm wrong, but from listening to Ms. Michael's argument, I think I was right in it. She has the other text messages from those 2 days, right? Somewhere she saw those. But doesn't say anything about them. Doesn't say anything about what those are. Yet, the one that occurs after on December 10th, well, one particularly,
Yeah.
she lays out in great detail. That I have a problem with because it seems to me, if I were the magistrate, I'm getting half the story. I'm not getting the full story. It might be one thing if what was testified to had been, well, these 10, that after that call on the 8th, there were other messages that were sent. They were work related. And then the 10th occurs. I just made that up on the fly. It doesn't seem that hard, but that's not what was said. And I'll be honest with you, I find it a problem when the court isn't given all of the information for the court to make a proper determination of probable cause. I really have a problem with that. Because quite frankly, I think that the defendant's due process rights, as well as the right of the people to be able to proceed with a validly sworn out complaint, are at jeopardy.
Does it impact the court to be mindful that investigation was then and continues to be ongoing, and that there was always the plan and expectation of getting phones and phone records and further interviews?
That, does it make me feel? No, it doesn't make me feel any better. And the reason it doesn't is because if you think you needed that, then you needed to wait. Okay. But my problem isn't what's going to be it gotten later. My problem is disclosing to the court what you have now. So that I realize whenever these complaints are sworn out, and quite frankly, whenever the court may be dealing with a moving case or a case that is, there's always this continuing investigation.
Sure.
So things can change. But so the parties come in, and what do the parties do? They give the court what they have at the moment they got it. All of that could change at some later date. So if you're asking, does that make me feel better? No, it doesn't.
As always, I appreciate the court's candor. I am happy to answer further questions, but my position remains that even if you excise out the statements that defendant takes issue with, calls false, calls inaccurate, what you're left with still is more than enough for probable cause, Judge. If you take the recitation.
But Ms. Smith, I don't mean to interrupt you, but it's not only taking out certain things. I would then have to add certain things.
You're worried about the omission.
Yeah, I'm very worried about the omission. I'm worried about the omission because those things at the very beginning that Ms. Sharp says create that context to the whole thing. I mean, the whole thing is sort of painted by that. And I think, quite honestly, that's why Detective Walker led with that at the swear to. She's painting this picture. And it's all, I tried to look at it as objectively as I could, looking at the swear to. It's all one-sided when you look at the other part. I think courts are entitled to more than that. You give us everything, let us make the call. That's what we do. But I don't think, well, what worries me, I won't say it in the definite. What worries me is the magistrate did not get that opportunity. That's what worries me. And if the magistrate didn't get that opportunity, that means what the people got may not have been a validly sworn out complaint in terms of probable cause properly being addressed, and that the defendant's due process rights might have been violated. That's my problem or my concern. And I don't know how, which is why I asked Ms. Michaels about specific cases regarding omissions, because it's really easy if there is information that's in, and when you look at how most of the courts address it, if something comes in and it's false or it's reckless disregard for the truth, and then the court gets to the end and the court just has to ignore that and then say, oh, is there still enough for probable cause? Quite frankly, that can be a very easy analysis. I don't know well, I won't, I'll figure it out, but the analysis where something's missing.
And I don't disagree with that. I appreciated the court's questioning along those lines. I also am unfamiliar with case law that addresses that concept. My gut reaction has been all along to say that is because those are issues that are addressed at the sort of test the evidence stages, like a prelim, a bind over, trial, things like that. But that's nothing more than a gut reaction. You don't ever want to endorse hiding the ball. You know, that's not who we are. That's not what the system is. That's not what the system should be. That's not what we stand for. Clearly, the court is taken with, and again, I appreciate your candor, taken with an omission to put an employer-employee relationship on the record at the swear to. I can't fix that in the moment. I continue to believe the remedy is a preliminary exam. The court obviously may disagree, and if we hold a Franks hearing on that, then we hold a Franks hearing on that. I continue to be of the position that once that relationship is over, there is more than sufficient behavior that was sworn to that satisfies probable cause for the stalking, which then satisfies an element of the home invasion third. I believe that's for sure what Frank stands for, Williams, Franklin, all of that progeny of case law, whereby if the courts are willing to still say there's more than enough probable cause here, even if I excise out legit untruthful statements, which don't seem to in any way have been shown here, not from my perspective. And if there still remains probable cause, then the warrant is valid and there is no need for a Franks hearing. Then it stands to reason to me that if the worst that we can say exists on that record is a void of a fact pertaining to their employer-employee relationship, that if there still remains adequate probable cause on that record, that arrest warrant should still stand and there shouldn't be a reason for a Franks hearing. And I think that's probably all I have to say on that, Judge. If the court has any further questions, please.
I do not.
Thank you, Judge.
Thank you.
I appreciate it. Yes,
Response.
thank you.
The first thing I'd like to address is the position the government is taking that there are enough stalking acts on December 10th after the end of the employer-employee relationship. Count one, home invasion, third degree, states that it is breaking and entering with the intent to commit a misdemeanor, and in this situation with the intent to stalk. So in order for home invasion in the third degree to have survive a probable cause analysis, relying on the acts post employer-employee relationship isn't good enough. They have to show that he went into her apartment with the intent to stalk her, which means there had to have been predicate acts of stalking prior to entering the apartment. If they are now saying that the only acts that we are relying on are the acts post leaving the apartment, the home invasion fails. And it should fail because there was no stalking prior to December 10th or after is our position. That's one point I'd like to make. Second point I'd like to make, in People v. Eichler, in paragraph 6.
Counsel, can I just ask one question?
Yes.
In regard to the stalking. You may very well be right. I don't think it's the time for the court to make the decision as to prior to. But after entering, leaving, and then texting, those could be non-contiguous acts that could constitute stalking.
Too soon to answer that, honestly. I haven't been, my mind
That means yes. But
no, not necessarily.
No, go ahead.
No,
You're not. I understand
Okay,
why you
stalking
want to
isn't-
answer that. But those could potentially formulate a stalking charge. I might agree with you that the stalking, as it's framed in the complaint, isn't the predicate for the home invasion. I get that. But that illegal entry or potential allegedly illegal entry and then the text message could do that.
Assuming it can show intent to harass and all these other elements
Understood.
that I would have to analyze, which is why I'm saying I'm not going to answer that until I actually analyze the fact.
That's okay. I got my answer. Go ahead. You can keep it with your argument.
But it's important, though, as to the felony. I mean, a felony is much more serious than a misdemeanor. So if the stalking fails as to going there with the intent to stalk, breaking and entering with the intent to stalk, that would have to have been a second or third act. You can't go and do something.
I'm not saying I'm disagreeing with you.
Okay.
I'm just saying
Thank you.
that you made a statement
Understood.
that I might disagree with, but go ahead.
The government also pointed out that there, in the fact pattern that she just relayed to you about Mr. Moore walking towards the complainant while he was holding the butter knives. I'd like to point out that the prosecution or the charging agency, they're the ones who get to choose. They didn't charge him with assault or aggravated assault or any assault. They looked at the facts and didn't even ask for that. So to describe him as dangerous and assaultive, they didn't even see that as assaultive on that day. I just want to make that point. Finally, the prosecutor also stated that there was further conversations with the complainant to flush out more of the history. That conversation occurred prior to the swear-to. The in-depth conversation with the complainant was documented in the police reports and is on body cam, video, audio and video. And at no time does she describe a history of domestic violence or a history of stalking. And one more thing is I was getting to Eichler, paragraph 6 The government tried to say that Eichler can only be applied to cases where it's a probation agent probationer relationship, that it's limited on its facts and should be seen as limited in its holding. Eichler actually states that the language from Eichler is this, that under Spalding, which is a case that they're citing, a reasonable individual is a reasonable person similarly situated to the victim, which necessarily means that we must consider Meyer's chosen occupation, training, and job-related responsibilities as part of our consideration of the circumstances or situation. It doesn't say we must consider one is a probation agent and one is a probationer. It specifically generalizes to the relationship between the parties, the employer-employee, occupation responsibilities. I just want to make sure Your Honor recognizes that Eichler is broader than what they are trying to make it be. Finally, with regards to the omission of the information of the employee-employer relationship, putting something on the record matters. That's why we have a record. That's why we rely on a record. That's why we make a record. If the employee-employer relationship isn't on the record, we cannot assume that she had any knowledge of it. Finally, if there was notice at all that, well, he's the head coach at Michigan, who knows that the complainant was his executive assistant? I put out there that is certainly not anything someone would take for judicial notice. I suspect that nobody knew that relationship until this incident happened. And if I may just confer with co-counsel briefly, one last point to make is the prosecutor presenting to Your Honor that it is a known fact that Sherrone Moore is the head coach at Michigan. That known fact would be from the media, from the news, from various other places, and it's improper for a judge to rely on that kind of information at a swear to.
Let me just ask one other question. Let's say, hypothetically, go through the entire thing. We have the evidentiary hearing. What do you believe the proper remedy is?
I think the proper remedy it's a couple step process. I think first, after the hearing and the evidence is presented, and Your Honor makes a determination of what was not true or recklessly presented because it's unsupported, and that is taken out, and then the omission is put back in, I believe it would be on Your Honor to then evaluate based on controlling Michigan law to determine if there's enough probable cause to support this not only the warrant, but the swear to. Not only the swear to for the warrant, but the complaint itself. The complaint has to be accepted by the court. The prosecution doesn't just, there is a process for Your Honor to review a complaint and accept it. So I believe a dismissal of the complaint would be appropriate remedy. I think a secondary remedy would be to suppress any and all evidence obtained after the arrest.
I guess maybe I'll put it more directly. Let's say you were to win on everything.
Yes.
There would be nothing that would prevent the people from seeking reauthorization.
That is correct. And it is my belief, based on my review of the materials, my investigation of this incident, that they wouldn't have probable cause to make these charges. I don't believe they have probable cause to make these charges.
Regardless, you just don't think that there is.
I believe when presented fully and fairly to a magistrate, I believe there is not probable cause to support these charges.
All right.
And I believe there's less probable cause now than there was when the incident happened.
I don't know what that means.
I believe that the evidence that has now been collected will show that there was not stalking.
Right, but
That's what I'm saying.
right now, I'm not dealing with any of that.
Right.
It's for the purposes of this motion.
Right. You're asking me, I believe the question was, let's say I win and everything's dismissed, they can go and just refile. That was the question, correct?
Yeah, there wouldn't be Nothing other than the fact that there might not be enough evidence to do so to prevent them from doing it, right?
It's my belief there won't be enough evidence to do so.
All right, very good.
Thank you.
Thank you. All right. Thank you, counsel, both of you for your argument and the manner in which you answered the court's question. The court does appreciate it. I'm going to take a break. I will come back with my decision. Why don't we look at it this way? Just give it time to come back. It may not take me that long to formulate everything, but come back on the record about 4:15. All right. You'll make sure that they know, get them down to where they need to be. Court stayed in recess.
All right. District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge Jason Simpson is back.
You may be seated. Thank you. Back on the record in the case of the People versus Sherrone Moore. Counsel is present as well as the defendant. And I, first of all, again, want to thank counsel for their well thought out arguments, and most of all for answering the court's questions, which since the filing of the motion for a Frank's hearing and to quash the arrest warrant have been part of this court's this extended thought process. The important thing to request for an evidentiary hearing pursuant to Frank's is, first thing to realize is that in Frank's, and the Michigan Supreme Court has made it very clear, Frank's, the requirement of an evidentiary hearing and the like based upon Frank's is the floor and not the ceiling. Michigan, I think, as the people have acknowledged, allows greater leeway and discretion for courts to hold evidentiary hearings regarding issues involving a search warrant, arrest warrant, or warrants, where it is in some way demonstrated that there is either evidence which is intentionally or unintentionally, in certain respects, misleading or false, or where there is almost a reckless indifference for the truth. This case brings up sort of a different issue, but brings up the issue of an omission. What is clear from this court's perspective, at least, is that an omission in certain contexts can be more damaging, more problematic, more troublesome than what might be an intentional misrepresentation. In either way, or in any event, this court is of the belief that at every proceeding, every representation made to a court should be a full and complete representation to the court so that all the parties can receive their due process. That includes the people, it includes the defendant, and anybody else coming before the court. The defendant wishes this court to have an evidentiary hearing regarding the issues, but fundamentally it's focused around certain portions of the omissions and sort of the context, particularly as I gather from the defendant's argument and what has been a concern of the court is the context of the relationship. People, on the other hand, don't believe that the court should hold an evidentiary hearing and that it would be an abuse of this court's discretion, which it has the discretion anyway. But it would be an abuse of that discretion to hold an evidentiary hearing. An abuse of discretion, what is very clear from the case law, only occurs where the result of the court's decision or use of its discretion is outside of the range of reasonable outcomes. I don't believe that granting an evidentiary hearing in this case would be outside the realm of reasonable outcomes at all. And just by way of context, in looking at the swear to by Officer Walker, what's clear, and also from the court's question, I think the parties realized where the court was going and should have. The initial part of that swear to is not set out by the representations of the alleged complainant in this case. It's all set out by her attorney, Ms. Sharp. Virtually every statement is a rendition of what Ms. Sharp said to the police. It isn't until a little bit later into that swear to that you get into particular statements that are made by the complainant in this case. When one looks at the Eichler case, one of the things that realize and where the defense was heading is that the context, and I read it as broadly as the defense does, that context to stalking charge, context of that relationship is critical to an assessment of that relationship and whether or not there's this harassing behavior of stalking going on. As I said, I can only imagine, but this court doesn't know what an executive assistant to a football coach does. I don't know if phone calls or messages might be exchanged all times of the night. I don't know any of that. I can only presume that if they are the executive to effectively a CEO, the range of their responsibilities, duties, communications is vast. But again, I don't necessarily know that, but it's something certainly that the court should have been informed of during the swear to. It's gone without any rebuttal that the phone calls that were alleged or alleged to have occurred during work hours, occurred during those times at which I guess most might think communications would occur. That the written messages in terms of text were admittedly employment related, at least is what's been represented to the court. I don't know why that wasn't given to the magistrate. I think that the evidentiary hearing would be necessary because there's no mention of the employment, that context given to the relationship. The context during the swear to is a one-sided rendition of things by someone else. It isn't. It by no means would constitute a full picture. More important, and it may go to the defendant's argument, although they didn't place it this way. I asked what might be particularly false in their statement. That's a tough question to answer. I appreciate the response that I got, but really I think that the falsity really comes in the way that it was sworn out. It at worst is false and an outright lie, excuse my language in that regard, or at best it is misleading. And particularly when it talks about the 10 to 12 phone calls and text messages, there's not one mention of the fact that those to which they could determine were work related. There's not a mention of it. That is a huge, in this court's perspective, that's a huge omission. Because immediately afterwards, again, there's like a statement from the complainant about these 12 calls, making them seem as though they are somehow related to some type of harassing behavior because there's nothing on the other side to say what it may be. And then the immediate statement afterwards is a text message that came after the incident or later on the 10th, after the issue regarding the complainant. Frankly, I think that was intentional. I think it was intentional to place a context without saying it. Give the court a context. If you look at the very beginning, that he's this monster, he's this person that's been doing all of these things, been harassing her for months. You lead that down into all of a sudden this day comes along or the 8th December comes along. There are these 10 to 12 phone calls, which one might presume would be a continuation of the harassment, but we now know are not any type of harassment. And then the December 10th incident. I don't believe a lot of times in coincidence. I don't believe that things happen all the time by accident. I agree. I think that that was an intentional misdirection to the court in terms of what this should look like. That doesn't mean that I would end up any place different than where the magistrate was, but the magistrate was owed the benefit of having all of that information prior to making that decision. It is in this court's mind a glaring omission to leave out or frame this relationship only in one way. That doesn't mean that it doesn't intertwine itself between the personal and the professional. It doesn't mean a lot of things, but this was not solely this personal relationship. And the magistrate should have been able to look at that and determine what it would be. That you can tell right on the surface. I would suspect as you dig deeper, there would be other issues that aren't painted in their full context in terms of what happened. So for those reasons, the court, in exercising its discretion, is going to grant the motion for an evidentiary hearing in this case to be held. Counsel, I'm going to have a couple of questions for you. One is in regard to availability, and I would indicate to the parties that I would like to hold the PCC date if possible. So I'm looking at getting to this in quick fashion. The other issue I would have, or question that I would have in setting a date, is what witnesses you would anticipate calling, and I'll start with the defense. You may.
So the question was, what witnesses will I be calling? So it would be the government's burden of going forward to show that this was done properly. So I guess maybe I can respond after they tell me who they would be calling. I don't know that I would be calling anybody once they put their case on.
Really doesn't matter to me who goes first, because I'm going to get to where I'm going to get to. Do you have what witnesses you would anticipate calling? Understanding, and both parties just need to understand, I think I made it clear as to where my reservations and concerns are. And you folks are going to know those witnesses that would be able to clear it up the best for the court. So.
I mean, off the top of my head, Your Honor, I think the court, I would imagine, would want to need to hear from Detective Welker, from, I would imagine, the victim, and from Ms. Sharp. Whether I should present to the court anybody other than those three is something I would, I guess, ask for a little bit of time to think about. Those seem the obvious ones, Your Honor.
Understand.
And if the court, I mean, I get it's my burden, my presentation, but I am mindful of the court's thought process, continue to be appreciative of the court's candor, If there are witnesses that the court would like to hear from, I would consider it my obligation to bring those to your honor.
Well, let me ask this, were there officers that were part of the interrogation process or the questioning of the victim in this case
There were a couple, yes, Judge.
that were, so, and the only reason I say those is because Detective Walker presumably would have received that information from them, or at least that's a possibility.
Some of it, yes.
Okay, so I think the officers that may have interviewed the victim in the case
There's at
would,
least two more that I can think of that.
okay,
One moment.
sure.
I would agree that Detective Welker will be a necessary witness. And then I don't know the name offhand, but the officer who had a body camera on at the scene would likely be a witness or potentially for purposes of impeachment if necessary.
But that officer, and maybe that's who I'm kind of referring to,
Yeah.
because that officer was one that I can't remember. I think somebody referred to it in something. And
Escobar Lawarca was the original respondent.
Great. that's it.
That I would think would be for sure.
Yeah.
There were a multitude of other officers that came and went.
Okay.
From that apartment, all of whom had body worn camera. Some asked additional questions, some asked mostly repeated questions. There was one officer who did a follow-up phone interview, whose name is escaping me right now, Peterson, and that is a recorded follow-up phone call, Patterson, with the victim. So those are two for sure. If you're
Okay.
looking to hear from and see body cam of interactions with the victim, so Escobar, Lawarca, and Patterson. If counsel or court would like all of those who responded, who had body worn camera, there's duplicated effort there, but
I don't know. Well, the court would have to see body worn camera. As long as there's an admission as to its foundation, I don't know that we're going to need the officer there per se. I mean,
Yes, we could talk about that. That's probably, we could probably stipulate to the foundation of those body worn cameras. There was the initial officer who talked to the complainant, and then later on, maybe a half hour later, there was a follow-up interview on site. I'm not sure if it was the same officer or not, but we'll make sure we figure out which body cams are relevant.
got it. Okay. Anybody else you can think of?
That's all I can think of.
All right.
either want the officer that took statements from the defendant, as those are also referenced in the SWIFT.
I think that would also be prudent to have that officer.
Suggestion. Counsel and I can communicate about hoped for, anticipated, expected witnesses. If I then compile a witness list, serve it on the court and counsel with perhaps a reference to just very minimal first responding officer.
Yeah.
Phone interview of victim. If then there are additional witnesses that anybody would like to hear from, I can consider it my responsibility to make sure.
All right, very good. Is that
That works, yes.
okay? Very good. Okay. I'm just looking at that list. It's going to be an all-day fair release. So, those of you that practice before me know that that's usually limited for me. However, I would have and can cancel dockets. I would have March 2nd and March 9th available. And if I cancel that, you have this also right. This is I cancel. So I would have March 2nd, March 6th, or March 9th.
Currently have a murder trial set to begin March 9th. might be resolved in the process of doing that. So in light of the 9th currently being occupied, the 2nd is the best bet,
Okay,
followed by the 6th, followed by, in the moment, not the 9th, but they may all wind up being good from my perspective.
got it.
Thank you.
I prefer the 2nd, March 2nd. I'm available that day.
Well, it's not Groundhog Day, so. March 2nd. 9 a.m. Okay, and we'll set the evidentiary hearing in this matter for March 2nd, 2026, 9 a.m. Counsel for the defendant will prepare an order consistent with the court's ruling today.
I will do that.
All right. Is there anything else from either side?
No, you're-
Thank
No. One question I did have, I know that at our probable cause conference, there were issues regarding documents from the University of Michigan. You had indicated that you may ask the court for a subpoena. I was having my staff on the out look for that. Has that been resolved in any way or not?
I've not done that yet. Why don't we have a conversation about that as well? Sure, we are.
All right. Why don't you guys talk about it? Just let me know. I was curious because it's one of those things on my checklist that wasn't checked off, so. Folks, thank you very much.
you.
Bond will continue. Court stands in recess.